Thank you.
Justice Gorsuch?
Mr. Kneedler, I want to probe this a little bit further because it does seem to me the status conduct distinction is very tricky. And I had thought that Robinson after Powell really was just limited to status. And now you're saying, well, there's some conduct that's effectively equated to status. But you're saying involuntary drug use, you can regulate that conduct. That doesn't qualify as status. You're saying compulsive alcohol use, you can regulate that conduct in public drunkenness, even if it's involuntary, that doesn't qualify as status, right?
Right.
You're saying you can regulate somebody who is hungry and has no other choice but to steal. You can regulate that conduct, even though it's a basic human necessity, and that doesn't come on under the status side of the line, right?
Yes.
Okay. But when it comes to homelessness, which is a terribly difficult problem, you're saying that's different, and because there are no beds available for them to go to in Grants Pass. What about someone who has a mental health problem that prohibits them, they cannot sleep in a shelter? Are they allowed to sleep outside or not? Is that status or conduct that's regulable?
I think the question would be whether that shelter is available.
It's available.
Well, no, available to the individual.
It's available to the individual.
But
it's just because of their mental health problem, they cannot do it.
I think there might be, I mean, that's the mental health
status or conduct.
Well, the mental health situation is itself a status.
Right, I know that.
Yes, but
it has this further knock-on effect on conduct. Is that regulable by the state or not?
I think that if the
all the alcohol, drug use, they have problems too. But you're saying that conduct is regulable. How about with respect to this pervasive problem of persons with mental health problems?
I think in a particular situation, if the person would engage in violent conduct as a
don't mess with my hypothetical, counsel. I like my hypothetical. I know you don't. It's a hard one, and that's why I'm asking it. I'm just trying to understand the limits of your line.
I think it would depend on how serious the effect was on the
It's a very serious effect. The mental health problem is serious, but there are beds available.
Well, what I was trying to say, it would depend on how serious being required to go into that facility was on the person's mental. If it would make his mental health situation a lot worse, then that may not be something that.
So that falls on the status.
Well, I guess you could put it that way, but I guess what I'm saying is that
that's what I don't know. I'm asking you. I really am just trying to figure out.
You could view that as
You're
status,
asking us to extend Robinson, and I'm asking how far.
Well, what I was going to say, you could think of it as status, but I think another way to think about it, and this is our point about an individualized determination, is that place realistically available to that person?
It is in the sense that the bed is available, but not because of their personal circumstances.
Right, and that's my point. It's available in a physical sense. It may be available to somebody else, but requiring an individualized determination might include whether that person could cope in that setting.
So that might be an Eighth Amendment violation.
Because it may not, yes, because
so
it's not available.
It's an Eighth Amendment violation to require people to access available beds in the jurisdiction in which they live because of their mental health problems.
If going there would...
How about if they have a substance abuse problem and they can't use those substances in the shelter? Is that an Eighth Amendment problem?
That is not sufficient.
Why? They're addicted to drugs. They cannot use them in the shelter. That's one of the rules.
Well, if it's the shelter's rule, then they have no. They can't go there if they're addicted. That's not.
So that's an Eighth Amendment. That's an Eighth Amendment violation.
No, the Eighth Amendment violation is prohibiting sleeping outside because the only shelter that is available
is not really available to that person.
Won't take them. Yes, and that's an individualized determination.
Same thing with the alcoholic.
Yes.
Okay, so the alcoholic has an Eighth Amendment right to sleep outside, even though there's a bed available.
If the only shelter in town won't take him, then I think he's in the same condition. And there can be all sorts of reasons, and the city doesn't
judges
normally...
across the country are now going to superintend this under the Eighth Amendment.
I actually don't think that it requires this. Again, I don't think we should let the Ninth Circuit decisions.
No, you want to
characterize.
Okay, yeah, you don't like the class certification, but that question's not before us, counsel.
No, but all we're talking about is the core principle of Robinson, which is you cannot punish someone for a status. And if I think communities guided by that principle, and it's the only principle a court should be enforcing, would retain a lot of flexibility.
How about if there are no public bathroom facilities? Do people have an Eighth Amendment right to defecate and urinate outdoors?
No,
Is that conduct or is that status?
It's obviously, there's conduct there, and we are not suggesting that cities can't enforce their...
Why not, if there are no public facilities available to homeless persons?
That situation, candidly, has never arisen, and whether or not they're, in the litigation, as I've seen, but no one has suggested, and we're not suggesting, that public urination and defecation laws cannot be enforced, because there are very substantial public health reasons for that.
There are substantial public health reasons with drug use, with alcohol, and with all these other things, too.
And they can all be...
You're saying the Eighth Amendment overrides those. Why not in this circumstance? Or
No, I'm not saying the Eighth Amendment overrides laws against drug use.
I know that.
Oh, I'm sorry.
I know that.
No, I misunderstood.
That one the government wants to keep. I got that.
No, I misunderstood your question.
Yeah.
Sorry.
Last one. How about fires outdoors? I know you say time, place, and manner, but is there an Eighth Amendment right to cook outdoors?
No, I think
that's an incident, a human necessity. Every person has to do.
But this is one of those things that is taken care of on the ground as a practical matter. There are restaurants where someone can go.
Well, no, we're talking about homeless people. No, they're not going to go spend money at a restaurant necessarily.
There may be inexpensive places. Some people get.
Let's say there isn't. Okay. Let's say that there is no reasonable...
And the local community...
Do they have a right to cook? They have a right to eat, don't they?
They have a right to eat, a right to cook. If it entails having a fire, which I think it probably would. But as I said, the eating, the feeding is taken care of in most communities by nonprofits and churches stepping forward, as they have for 200 years.
But if there isn't, there's an Eighth Amendment right to have a fire.
No, we are not saying there's.
Well, I thought you just said there was.
Well, there's food that you can eat without cooking it. They could get a handout from an individual. People can beg for money. There are ways that this works out in practice.
Last question. I'm totally sympathetic to the idea that there might be a necessity defense in these cases, and there's a footnote in your brief that indicates that in a lot of cases you could maybe bring advanced preliminary injunctive action, at least as individuals. And I don't even see why you couldn't do it on a class-wide
we haven't ruled out class.
basis.
We haven't ruled out class.
Well, I thought you did in that footnote. You said, the whole mistake here is that this was done on a class-wide basis. Why couldn't it?
Without sufficient inquiry into the individual circumstances is what, particularly with the two class representatives here.
Thank you.